Thalia is a professor in law at the University of Technology of Sydney. Thalia's research delves into the role of the criminal justice system in reproducing the state's colonial relationship with Indigenous peoples. Thalia is active supporting Aboriginal families who have had their children taken by the state and affected by deaths in custody. Please welcome.
I'd like to acknowledge the traditional owners and recognise that this always has been and always will be Gundabara land. I want to pay my respects to Aboriginal and Torres Strait Islander people here today. And as part of what I'm going to talk about, I'd like to pay my respects to the Aboriginal young people who endured the torture and humiliation in detention and who came forward to tell their stories to the Royal Commission into the protection and detention of children in the Northern Territory. I need to warn you that I'll be retelling some of their stories that are brutal, that are dreadful, that are racist and simply heartbreaking. So I understand if some of you may need to leave the room. I also pay my respects to the Aboriginal people who responded to calls from outreach officers to give evidence or engage with the Royal Commission consultations. Most of these people never heard back from the Royal Commission once its findings were handed down. The budget for follow-up and feedback to communities was reallocated to the Royal Commission into banks. So before discussing the substance of the Royal Commission, I want to make 2 points. First, despite the Royal Commission being concerned with youth detention in the Northern Territory, it should not obscure the fact that youth detention is a problem everywhere in Australia and, as we'll hear next, across the world. And it's particularly a problem here for Aboriginal children. In fact, we heard this week, and this is not unprecedented, that every single child, 100% of children in Northern Territory detention are Aboriginal. Detention centres are a problem because they can inflict torture, violence and humiliation. But they're also a problem in themselves by simply locking up children. This is an abusive process. Taking kids from families, schools, communities and society and confining them behind bars dehumanises them and alienates them and treats their lives as wasted lives. So I've got up on the PowerPoint the terms of reference of the Royal Commission, and they were limited to an investigation into the abuses in Northern Territory youth detention as well as child protection. They did not come to grips with the broader problem of youth detention across the country and overlooked the fact that youth detention in the Northern Territory is exclusively a problem experienced by Aboriginal children, so it obscured issues of racism. But we know from the much earlier Royal Commission, the one into Aboriginal deaths in custody in 1991 and the years beforehand, that terms of reference can be conceived very broadly. And in that Royal Commission, they did look at systemic and factors relating to colonisation. So there was every reason why this Royal Commission in the Northern Territory could delve deeply into the racial policies and practices in the Northern Territory broadly. The other point I'll make is that although the theme of the conference is on Indigenous overrepresentations in prisons, and this obviously includes reducing overrepresentation in youth detention, we need to think beyond the overrepresentation framework. We need to consider alternatives to punitive state systems altogether, rather than simply levels of representation. This point was made loud and clear by Aboriginal elders who appeared before the Northern Territory Royal Commission. They spoke of the need for healing and wellbeing programs run, designed by Aboriginal communities, and self-determination for communities and families to support their children, rather than acceptable levels of representation in youth detention. So now I want to provide a microcosm of life in Dondale and Alice Springs detention centres that's based on evidence in the Royal Commission, my discussions with some of the young people and their families who experience this system, and footage from Four Corners and other media. And this life, although it was told last year and relates to the last few years, it still very much is alive today. So, at a glance, the detention centres are a series of concrete cages, especially at the new Dondale Detention Centre, the so-called new Dondale Detention Centre. They were redesigned, redesignated adult prisons that had passed their use-by date and were described by the Corrections Commissioner, Ken Middleton, as only fit for a bulldozer. Aboriginal children would spend long hours behind bars with nothing to do. There was an absence of airflow and natural light. Children received little food, and what they did receive lacked nutrition. They had limited access to programs, education and training, health services, or cultural and family supports. Aboriginal children are sent to detention, often thousands of kilometres away from home and country. Their requests to attend parents' funerals and sorry business were often refused, and for one child, the Royal Commission heard that after he was told his mother had passed away, he was sent straight to an isolation cell, apparently for his own safety. And this is a picture of one of those isolation cells in Dondale. The dark and dank segregation units housed children for up to 23 hours per day. They were default accommodation for children with mental health issues, children who were non-compliant, and children who were deemed high risk. Across detention centres, verbal abuse was commonly hurled at Aboriginal children by guards and allied workers, and the Royal Commission heard such slurs as children being called stupid black cunts, camp dogs, oxygen thieves, waste of space, little black poofters and fucking sluts by guards and allied workers. Aboriginal children were yelled at and ridiculed for speaking in language. They were insulted for displayed disabilities, and some children had their hearing aids taken off them as punishment. Guards routinely inflicted violence on Aboriginal children in detention. They were punched, choked, hit with instruments and had their heads smashed into concrete walls and floors by guards. And this is one picture of young Dylan Voller being bashed by Derek Tasker, who was ultimately prosecuted, but in the end he was found to be innocent because these actions were reasonable, even though they were unprovoked. And in the bottom corner is another picture of guards attacking Dylan. So when Derek Tasker was asked by the Royal Commission, and he's pictured there in the bottom corner, about this incident, he denied it. And when pushed on the basis that there were CCTV images, he said that it happened, but the court found it to be reasonable, so he was not owning up to it. And there was never at any stage an apology or any remorse demonstrated by these guards. So children were also humiliated by being watched and filmed in the shower and on the toilet by guards, pat-searched on their naked bodies, stripped naked with knives, including young girls who were stripped by several male guards on a number of occasions. This is a picture of Conan Zamolo, who was named in the Royal Commission's final report. Him and others told children to, quote, suck my dick while they were in bed and eat bird poo as they regarded to be a joke or a game. At its worst, the violence was nothing short of torture. The image of Dylan Voller on the mechanical restraint chair and hooded for hours has become entrenched in Australia's neo-colonial history. Dylan told the Royal Commission he had panic attacks, cried and vomited in his mouth while he was on the chair. He said he felt like he was going to die, and the saddest thing was there was no one there responsible for him, no one there to come to his aid. And this has been compared with the torture in places like Upper Grave or Guantanamo Bay, as you can see in this cartoon. But it was not only young boys, it was also young girls. A 16-year-old Aboriginal girl was highly traumatised and self-harming after repeatedly being placed in isolation cells. When she started acting up she was strapped to the mechanical restraint chair and given a chemical restraint that involved doping her up to make her docile. As a result of these cruel interventions, her mental health deteriorated and the response was to send her to an adult prison. One of the most brutal incidents at Dondale, and I'll finish on this one, is the gassing in August 2014 when the guards fired CS tear gas, a gas that contravenes the UN Convention on Chemical Weapons, to 6 children in the segregation unit. 1 child was permanently blinded and others have had long-term health problems. After the incident, they were not treated but instead sent to an adult prison where some of them remained. And so that's the picture of the night in August 2014 where the boys, some of who were resting or playing cards in segregation, were fired on because of a perceived risk incident. Now, I don't have time to talk about the harm and violence that faced Aboriginal children in the child protection system. Judge Myers has given you an insight into some of the problems there, but the Royal Commission also heard accounts of open abuse and sexual assault inflicted by people in residential institutions or foster carers on Aboriginal children in protection. I will make a few brief points about what the Royal Commission observed very generally. First, over 80% of kids in child protection in the Northern Territory are Aboriginal. Most of them are forcibly removed from Aboriginal families. The great majority of kids in detention were also in the child protection system. So over 60% were also in the child protection system. Kids who are in child protection are very highly policed, and the Royal Commission heard that they could be policed and prosecuted for incidents such as squirting tomato sauce on the kitchen table. So any type of minor misdemeanour could be a segue into the criminal justice system. The child protection, youth detention or juvenile justice system in the Northern Territory are so closely aligned that the same department in the Northern Territory, Territory Families, administers both of them. And in outreach with Aboriginal communities, Aboriginal people told the Commission that child protection for them was one of the major inhibitors to their well-being, and it had wreaked havoc and tragedy on their lives and on their communities. So absolutely, there's a need for there to be very serious consideration and review and systemic change within child protection. And it was a really tall order for the Royal Commission to give substantial attention to both in a short period in which it ran for about 14 months. So I'm going to go through some of the proceedings of the Royal Commission to give you an idea of how it was run and how it produced the recommendations that it did. So the findings and recommendations of the Royal Commission reflect a process of, I would say, non-Indigenous lawyers and managers primarily asking non-Indigenous people about what needs to be changed, with some outstanding exceptions such as Indigenous Senior Counsel Tony McAvoy and other Indigenous outreach officers. But in the main, it was a process involving non-Indigenous people asking questions relating to their own system. Local Indigenous people in the Northern Territory played a much smaller role in the formal proceedings, and this shows in the final report. However, many young people gave evidence. They found it difficult, given the partiality of the Northern Territory government and its lawyers in favour of the guards. The Northern Territory government always responded to evidence by Aboriginal young people with a bundle of documents to discredit or refute the young person's evidence and contradict their accounts. And these are some of the people who were both responsible for the abuse in Northern Territory youth detention. So you've got Ken Middlebrook, the person standing up who was the Corrections Commissioner. You've got John Elfrink, the Attorney General and Corrections Minister in the Northern Territory, and James Sizeland, who was the General Manager of Don Dow. Now, rather than simply being taken to task on the abuse and torture in the detention, they were actually asked what could be done to improve the system. So they were seen as the experts on how things should be changed, and it reflected a lot of the tone of the Royal Commission. Now, by contrast, the Aboriginal children who were in the system underwent very aggressive cross-examination, including primarily Dylan Boller. And he was accused by Northern Territory government lawyers of lying, of manipulation, of provocation. And after his cross-examination, no other Aboriginal young person gave evidence in public or used their real name. And a significant number of Aboriginal children who had experienced torture in detention stayed away altogether. The overall tone of the questioning by Royal Commission lawyers and commissioners tended to problematise children, Aboriginal children, families and remote communities, rather than problematising the penal system. Witnesses were constantly asked about the difficulties with managing Aboriginal children, the problems facing Aboriginal families and the deficits within Aboriginal communities. The premise was that the state needed to step in to fix the problems. By contrast, the Royal Commission in the main failed to focus its proceedings on the strengths of Aboriginal children, the strengths of families and communities and how these may be supported. On some days you could leave the Royal Commission feeling as if it was an inquiry into the harm that the Aboriginal young people were presenting rather than the harms that the youth detention system was presenting to them. But there were exceptions. And halfway through the proceedings in March 2017, an Aboriginal elder from Tiwi Islands, Marius Parantata spoke about the children he saw when he visited them in Don Dow. And I quote, he said, "These are special kids who can become good leaders regardless of their situation. They are good-natured persons and can be respectful of culture. With guidance, they are our potential future leaders and are necessary for the survival of our culture." Other Aboriginal witnesses from Central and Northern Australia spoke about their underfunded, community-owned family programs. They talked about the importance of culture, language, ceremony and being on country for their children. These were not simply avenues for keeping kids out of detention. They were essential programs for the maintenance of kinship, connections to country and cultural survival. However, local Aboriginal witnesses were a small fraction of the witnesses, like I mentioned, mainly outside experts or people who were within the management of detention, and their narratives tended to prevail. This slide is the senior counsel for the Northern Territory government, Sonia Brownhill, who took a particularly aggressive approach to the Aboriginal young people in questioning. The proceedings were highly legalised and held in formal settings such as courtrooms in Darwin and the Convention Centre in Alice Springs. They were disconnected from the places where many Aboriginal people in detention came from and diminished hopes of place-based justice responses. By contrast, the Royal Commission into Aboriginal Deaths in Custody, for instance, had their hearings held in community centres that were more culturally safe for Aboriginal witnesses and relied on information sharing techniques that didn't involve direct questioning by lawyers all the time. For young people especially, the direct questioning approach only elicited very, very cursory responses in hearings. The approach of the Royal Commission into Aboriginal Deaths in Custody produced fuller stories of the 99 people who had investigated. We got a sense of their upbringing, their family, their community, their experience of injustice, and not just their time in custody. Both the interim and final reports of the Northern Territory Royal Commission were devoid of holistic accounts of young people. It produced a booklet, this one on the slide, from young people called Their Voices. but it really truncated their voices and experiences rather than enlivened them with very short quotes. So we never found out about, for instance, the person Dylan Boller is, about his love for children, his relationship with his sister Kira, his sense of justice, and his support for many of the young people who were mistreated in detention. They really relied on Dylan both during their time in detention and afterwards. So what were the witnesses asked? And this is one of the witnesses, Sally Cohen, one of the managers of youth detention, who was asked over 2 days what some of the solutions were. And they were asked about solutions in terms of how could detention be made better. Sally Cohen was someone who was witness to the 2014 gassing of the children. She described the whole process as alike to being in a video game. So this was seen as the type of expertise the Royal Commission relied on. Countless hours were spent addressing improvements in detention relating to staffing and training, cultural competence and trauma-informed programs, treatment and diagnosis of young people's problems, improved induction manuals, reporting mechanisms and oversight systems. By contrast, diversion, community-based programs and support for families to care for their children received less attention. Often communities and their remoteness, their language, their culture were regarded as barriers to access to services. And Peter O'Brien, Dylan Boller's lawyer, observed the questioning in the Royal Commission as reflecting a historical attitude that the empowerment of Aboriginal people is too hard, will cost too much, the area is too remote, the right people are not available, it requires too much work, he said. But Aboriginal witnesses told the Royal Commission that culture was their richness. The right people are already in community. We don't need them to come to us. And that the right work is already being done. So, what were the findings and recommendations of the Royal Commission? The key finding was that the Royal Commission was that there were systemic and shocking failures in youth detention, and this included breaches of the United Nations Convention on the Rights of the Child. It handed down 227 recommendations, mainly focused on making detention as well as child protection less abusive and more transparent. Fewer than 20%, I have counted them, focused on diversion, and only 3% focused on either community consultation or community controlled programs. The recommendations include closing down Dondale and Alice Springs detention centres and building new purpose-built centres, investing in health screening programs and education in detention, diversion strategies such as bail support and non-custodial sentencing programs, and the establishment of 20 family service hubs across the Northern Territory. There was also a focus on bail accommodation, which Judge Myers identified as a key issue, and certainly in the Northern Territory, where over 70% of the detention population is on remand, it's especially important. There were recommendations about reducing the use of force and isolation in detention through greater safeguards and trauma-informed training for guards. It also recommended a modest increase in the age of criminal responsibility from 10 to 12 years old. So the Northern Territory government has agreed to implement all of these, at least in principle. Following the Royal Commission, it committed $70 million to new detention centres and has introduced and had legislation passed that will increase safeguards against abuses. But there's still provision for much of this violence to occur. It's just it has to be proven to be an emergency. And that's fairly broad, not only to protect people, but to protect property as well. The federal government has been more reticent, claiming it does enough to protect Aboriginal people in the Northern Territory and will not be reconsidering its overall policy or funding. There was no overarching recommendation about supporting families, communities and Aboriginal organisations. despite the overwhelming evidence by Aboriginal people in the Northern Territory that this was needed and that this had suffered since the introduction of the Indigenous Advancement Strategy in 2014 and under the Northern Territory intervention since 2007. Moreover, the Commission noted that there were a number of officers who had conducted particularly egregious conduct. It didn't recommend charges, but it recommended investigations. It was recently announced that none of the guards will in fact be prosecuted, and I can talk more in questions about some of the failures of previous prosecutions. Finally, I just want to mention some of the barriers to implementation and effective change in the youth detention system in the Northern Territory. The first one is an overall ideology of law and order which has continued unabated. The Royal Commission heard that the previous Chief Minister Adam Giles, sent a clear message about tough on crime. He said that if he were Corrections Minister, he would dig a concrete hole and throw in all the criminals. And this mentality has not really changed under the current government. Straight after the Royal Commission ended its proceedings, the Northern Territory Government unleashed the Territory Response Group Police Unit to monitor young people, and this is an image of what the unit looks like. And the Northern Territory Government continues to refer to Aboriginal children as a problem youth. A combination of tough on crime and problematising Aboriginal children is a recipe for ongoing abuse. The other key barrier, I think, is the Northern Territory intervention. Since 2007, this has been a racially discriminatory set of controls in the Northern Territory, and here's an image of the army going into Mutitjulu that kind of set the tone for the intervention, very penal approach. And the intervention is not a context or a background or an incidental feature of youth detention. It's central to the rise in incarceration. Youth detention has doubled since the intervention. And it's also set up a framework for torture in detention. Pat Anderson told the Royal Commission that the intervention sanctions the torture of our children. Don Dale, she said, is a continuum of the intervention and how we treat Aboriginal people in the Northern Territory. Yet the federal government continues this policy. And even though there was some mention, although no recommendations for abolition in the Royal Commission's final report, the federal government hasn't responded by reassessing this stance. So in conclusion, when the Royal Commission's final report was handed down, the Northern Territory Chief Minister, Michael Gunner, said the findings were a stain on the Northern Territory reputation. But this stain has a long history. It is clear that penal institutions have failed Indigenous children. As a starting point for moving on, we need to talk about racism as part of our colonial penal legacy and how Aboriginal children are targeted by law enforcement. Once we confront the racism of the state, we can move away from deficit-based risk approaches to Aboriginal children and look at their strengths and needs and the value of models of social, cultural and emotional well-being for Aboriginal children.